Okay. Oh, and as far as sexual orientation, that came after transgender, interestingly enough, and that's because of court cases. It actually was never EEOC's position, this, that, or the other. The position was that, the courts have decided that Title VII doesn't cover this, and that if you're gay, we can't say under federal law that you've been discriminated against because the courts won't let us. But we were pushing that, and one of our commissioners, Chai Feldblum, is openly a lesbian woman and a brilliant woman. She taught at Georgetown, and she fought for that forever. And so we were opening the charges and taking charges for people who were discriminated against because of sexual orientation discrimination. And I don't know what's happening now. But as of October, it very well could be different now. But that's how much some of this stuff matters. I don't think I can go into pregnancy discrimination. There's a real interesting case that deals with UPS, but that's been decided on the woman's favor in the Supreme Court. Basically, being pregnant.
I just want to say really quickly, you can't discriminate, and a lot of women truckers believe that you can discriminate. We've heard in Idella on the other board in the other organization, senior female drivers.
Should I apply for this job? And all the people that came back that know nothing said, okay. Oh no, you can't go to work there. They won't hire you. It's a health problem. Blah, blah, this, blah, blah, that. Oh, this makes sense. And I told them, it's against the law.
It's against the law. It's against the law. PDA is part of Title VII, and you cannot not hire somebody or fire them because of pregnancy. So, all right, the last one, or the one that really we get a whole lot of charges on, is the ADA, Americans with Disability Act. That's another one we've had a really, really, really tough time. And I mean, okay, let me just tell you that before 2008 amendment, coverage for all of us, any of us employees under the ADA was so difficult to prove that I would have to show, let's say you're blind, and you come in and you say, they didn't give me a job because I'm blind. Before we got into anything about whether or not they discriminated against you, I had to prove that your being blind was a disability under the ADA. And there were courts that said no because you used a guide dog, and therefore you had mitigating circumstances, and therefore you weren't covered under the ADA. It was really horrible. I mean, I did some research at the time, and there's like 1 or 2% of any ADA cases that got beyond summary judgment, and they're very expensive. It's another reason you need the government sometimes to be doing these cases. The prime case, 63 women, we traveled all over the country, we worked all night. It would be expensive if a private attorney took that. They wouldn't take it. So that's why it is really important to know what these agencies should be doing. So the important terms under the ADA are disability, reasonable accommodation, and undue hardship. And there was, an amendment in 2008, and now most conditions are covered, so I don't have to prove that somebody who's blind is meant to be covered. Okay, so you would think this is obvious, but somebody with cancer, heart disease, diabetes, depression, anxiety, panic are considered covered by the law. They have a physical or mental impairment that substantially limits one or more life activity. A record of such impairment. I know what I was thinking. You had mentioned HIV. And a lot of HIV cases, I got some really great settlements for people on those because they were what we call regarded as having an impairment. So we get a young woman who is working at a gas station, right? And in the gas station, they make fried chicken. And part of her job as somebody who makes fried chicken is to reach into a bucket that has chicken, which has bones, which means that she may end up bleeding. And if she bleeds, everybody in St. Louis County will have HIV. So that's kind of how employers dealt with HIV. Well, that's illegal. That's called regarded as disabled. The point being that it was really easy for us to get the health department to say, here's what you do. You wear gloves. And no, you can't fire somebody because they're HIV positive. And I mean, I had one where it was a woman who worked at a hairdressing, and she drank soda, and they found out she was HIV positive, and they fired her because they thought somebody might pick up her soda. I mean, you know, discrimination's ugly. It's just freaking ugly. And some of that stuff was really ugly, and I'm glad that we have the agency and our rights to help us. Okay. Let's see. So a reasonable accommodation, the easiest way to describe a reasonable accommodation, I'm trying to think in trucking, and I'm afraid I don't know enough about physically what happens in a truck, but I think you guys will probably be able to figure this out. Here's the deal. If I am deaf, you provide somebody who can interpret by sign language or however I need it interpreted, the minutes or what went on in the meeting. If I'm blind or have very bad eyesight, you provide help with the computer so I can use the computer. I mean, that's what the ADA was about. There's something like 93% of disabled people at the time, it wasn't Bush, shoot, it was the guy before him, true to that. But you know, you are protected if you can do the job. Now, the point being that some people will say, okay, if you modify the equipment or the devices or whatever, you may, and we spoke about this in trucking, might put somebody in danger, but that's an undue hardship, and we'll talk about that. That would never happen, and we certainly wouldn't have ever taken a case. A case that we took, for instance, because we took cases, we were national, so we could take them, big corporations around the country. We took a case where UPS, and I don't know if we settled it yet or not, would not, they had a policy, basically, a practice that said, okay, you're on leave for X amount of time, and it wasn't a small amount of time, actually, it was a pretty decent amount of leave, but there, at the end of this amount of time, you cannot come back to work, it's too long. That actually is a violation of the ADA, because every time you make a decision as to whether or not you can come back from leave, you, UPS, have to show that it would be an undue hardship. The bigger you are, the harder it is to show undue hardship. In a lot of Walmart cases, and we were usually, if we were able to show the person was disabled and they asked for a reasonable accommodation, both of those things, see, people have to do, they have to go through the steps. You have to ask for the reasonable accommodation, and if Walmart or UPS or some of the really Nestle, some of those big companies did not give them a reasonable accommodation, it was very hard for them to argue undue hardship, because if I said it to mom and dad company, I need you to bring in a new computer and this kind of a desk and this and that because I am quadriplegic and I have difficulty seeing, and you have 15 employees, you're covered under the ADA, you have to have 15, but I will never be able to get you to do that because that's an undue hardship. If what I'm asking you to do would put the public at risk, that's an undue hardship. So it's sort of a back and forth thing. But if you're disabled and you're just getting the, no, we're not going to do it, we're not going to let you have a dog in the truck, you may very well, at least at that point, you need to ask or go forward to the EEOC.
Next slide.
I thought you were going to say something. Okay, so an undue hardship is an action requiring significant difficulty or expense when considered in the light of a number of factors, which are, as you can imagine, then what am I asking for, how big is the company, and so forth. A larger employee is going to be expected to make bigger accommodations than a smaller employee. Kind of makes sense, right?
Yeah.
You're not going to be able to ask a little employer to do that. And, okay, am I almost done? I think I am, actually. Oh, and here's some things that you could think of and that we obviously have the right to ask for. Cancer is an interesting thing because if you have cancer, you may need leave, for instance, while you're getting chemotherapy and radiation and during the time maybe you have a surgery. But it's interesting because then you may still be considered disabled because it may recur. So that's kind of an interesting one. But, and here's I think is important, is an employer is not required to lower quality or production standards to make an accommodation or to provide things like glasses or hearing aids. And then, you know what, the age discrimination in law, it's straightforward as it is difficult to win. 40 and older we're all protected because if we are discriminated against based on our age. There's case law now that makes it very difficult to win those cases because I could fire you for anything that's not age. And it's really hard to find that perfect employee. I had one that just settled for $300,000. She was the perfect employee. And her case was almost the perfect case. That's one out of like a million. Most of us have something where an employer could find a reason to fire you, and so it's pretty difficult sometimes to win an age case, and there's not a whole lot of litigation right now. Okay, man, that's okay.
Keep going.
Yeah. Okay, now, another thing about cancer, I want to talk about something called the Genetic Information Non-Discrimination Act, and basically it's just called GINA. It's actually very important for all of us. Do you guys ever get inquiries when you apply, I don't know, to a job that asks for a lot of medical background, kidney disease, you know, anything in your medical background? So that can be legal because of the industry you're in and because of DOT standards and so forth. However, watch for this. It is never, until the Republicans change it, as of today, it is never okay for an employer to ask family history or to ask you to give a blood test for genetic testing. And this is all pretty recent. I'll give you a little bit disclosure, probably more than you need, but I had cancer. I was worried about my kids. The thing I was most worried about is them getting cancer, right? Well, what do? You take genetic tests. I'm scared to get a genetic test because I sure as hell didn't want somebody to say 10 years down the road, your mother tested positive for whatever gene, therefore we're not going to hire you. Those are really important things, that you have the freedom to get genetic testing and that you don't have to worry about your kids, you don't have to worry about yourself. Those are, right now as we speak today, those are protected. You cannot, your employer cannot get your genetic information. They cannot ask family history. There is a bill that is just about out of a committee in the House that will pretty much overturn all this. So under the ADA, I can't ask you before I hire you if you have heart disease, if you have cancer, if you have any of these things. I cannot ask those things before I hire you. I can if there's a very high standard for this. If there's something like, okay, let's say you're working in an area where you have to wear masks, and sometimes people with asthma have difficulty wearing the mask. So there are times when an employer can specifically ask somebody personally, do you have this problem? Can we accommodate you? Blah, blah, blah. But there really are very few times when an employer can ask you anything about your health before they hire you. And as of right now, there's no time that they could ask about your genetic or family history before they hire you. So bottom line is, the rights are there. We need to educate ourselves, and we need to hold the agencies and the legislature and the president and all those folks accountable so that you don't lose those rights.